Okay, let me email Stephanie and see. Is that included?
All right, good morning. Welcome to the 294th District Court. My name is Judge Chris Martin. I'm going to call this morning's docket. When I say your name, please say present or here. Raise your hand so I can mark you down. Guadalupe Bahina.
Present with counsel.
Thank you, Mr. Noel. Vincent Freeney. Vincent Larome or Laramie Freeney. Jennifer Lynn Gonzalez. Jennifer Gonzalez. Letitia Hill. Is this today's docket? Juby Landaverdi. Lonnie Richardson. Lonnie Jean Richardson. Josie Bohannon. Josie Cheyenne Bohannon. Nicholas Crouch. Nicholas Scott Crouch. Joseph Howell. Chastity Smith. Chastity Renee Smith. Jamie Johnson. Adrian Serta. Is it Mr. Austin? Yes. Thank you, sir. Bob Truitt. Thank you, Mr. Biggs. Cameron Martin. Sir. Aaron Vasquez. Houston Carpenter. I saw Miss Chester outside. Is she with Mr. Carpenter? Someone different. Houston Scott Carpenter. Jackie Elliott. Chase Enox. Okay, thank you. Garion Hamner. Christopher Nash. Jeannie Hughes. All right. Thank you, Mr. Hawkins. James Wright. Thank you, Mr. Hawkins. Misty Backus.
Judge, I have sent out the previous today as well as this morning.
Thank you, Mr. Mann. Joshua Holloway. Joshua Dwayne Holloway. Theodore Houston. Keisha Kaufman. There's a waiver of arraignment filed, approved, pretrial was set May 12th. I've got you, Mr. Chambers. Yeah, I signed that this morning. Braylee Littlejohn. Charlotte Robinson.
Ms. Robinson.
She's still in the Nexus Recovery Center.
I think March 31st.
Okay, we'll recall that. Dennis Ray Jones, there was a motion for continuance filed that was granted. Docket call has been reset to March 31st. Mr. Jones here? All right, Mr. Jones, once you check in with the pretrial release officer and sign a notice of appearance, then you'll be free to go. Your attorney is in trial today and could not be here. Requested continuance. I granted that. So if you want to meet with Mr. Waddell and then sign a notice of appearance, then you'll be free to go. Okay. Jason Mays. Mr. Logan also filed a motion for continuance. Mr. Mays here? Okay, great. Thank you, Mr. Motion for continuance filed, granted. Arraignment was reset to March 31st. Guy McSpadden, waiver of arraignment filed, approved, pretrial set April 26th. Josue Rodriguez. Mr. Rodriguez. It's going to be a little bit late, and there was a continuance filed by Mr. Versace on that. Court has granted that and set docket call also on March 31st. However, he is ordered to appear, sign a notice of appearance, and meet with Mr. Waddell for pretrial release purposes. We'll reset both of his cases to March 31st. Stephen Cross. Debbie Spriggs. And then Travis Kenner will be at 11:30. Is there anyone who's in the courtroom whose name I have not called? Your name, sir? Guy McSpadden? No.
Scotty.
Scotty Petty.
February 10th, and he was sick at COVID, and it was one where we got your documentation. A couple days or something, you withdraw the warrant, and then I told him to be here next up next court date. I don't think we actually had everything official date for the due.
Okay. You're writing that. All right, and counsel, what I'm going to do is, if you want to go ahead and form a line here, if you're ready, then I'm going to call you as you line up. Don't want to start doing that. Mr. Sanders, do you have? Step up. No, that's okay. I'm just going to look at this. All right, Mr. Biggs, who are you ready? All right, so, it's going to be a plea on both of those? Yes, sir. Okay. Do you have any other counsels ready, Mr. Hawkins? James Rive, who come forward, please, sir. It's a CR 21-307-308. Let's give him a chance to get up here. All right, Mr. Rife is set for pretrial today. Mr. Hawkins, do you have any contested pretrial motions that need a hearing?
I think they were actually, I was also having a Senate requested for, spoke with the prosecutor this morning, and she directed me to send an email out to, so they'll attach it. So I just need to get this reset with this, so I can get that discovery.
Okay, so you didn't have any online discovery or digital discovery? Correct. Hazel, do you know, was there not a letter of rep to?
Your Honor, we had Mr. Hawkins in the portal, but we had not selected discovery to send to the portal. We will fix that today. I've let Mr. Hawkins know. Everything else looks like it's set up to do that, so that's 30-second thing.
I'm on the portal. I haven't sent it, but
Right. Yeah, I just was trying to figure out why there was an issue that it resets us another 30 days out. All right, are you available on April 14th, Ms. Rollins? All right, Mr. Wright, we're going to set you for an additional pretrial hearing on Thursday, April 14th at 9 a.m. Once you sign and get the yellow copy, you're free to go, sir.
Thank you, sir. Thank you, Your Honor.
You're welcome, sir. Is Jeannie K. Hughes here? Ms. Hughes? All right, court will have her name called later. If she makes an appearance before you, we'll give you a call. Thank you, sir. Yes, thank you, Mr. Robbins. Appreciate it. Do you have any other counsel that's ready? You may.
These are all three of Mr. Biggs' clients. He was waiting on me.
No problem. Bob Truitt. This is cause number CR 21401, State versus Bob Henry Truitt III. We show that we're set for a plea. Are we pleading or just waiting for the trial today?
we've executed a waiver of jury trial. Yes.
All right, Mr. Truitt, if you'll raise your right hand, we'll place you under oath. Mr. Truitt, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, let me put your hand down. You are Bob Henry Truitt III, is that right?
Yes, sir.
Mr. Truitt, have you signed a document entitled Waiver of Jury Trial today?
I'm not sure if I've signed anything yet, but I signed. Okay, yes, sir. Yes, sir.
Okay. And so did you read this document along with your attorney, Mr. Biggs?
Yes, sir.
All right, do you understand what this document means?
Yes, sir.
Can you tell me in your own words what this means?
The waiver for pretrial, basically not going to trial and coming back for a plea.
Okay, I think that's partly right. So you understand that this document waives your right to a jury trial, and that's an absolute right that you have under the Constitution, so that this allegation that's been brought against you can be tried before a jury of your peers. You're the only one that can waive that. And so you understand that you must do so of your own accord. That means no one's pressured you or forced you to do that. And once the court approves the waiver of jury trial, that right may not be restored to you later if you decide you change your mind and you don't want to enter a plea and you want a trial. Yeah, you may be forced with a trial before the court. That is a trial before a judge, where the judge decides the facts of the case and decides whether you're guilty or not guilty. Do you understand that?
Yes, sir.
And you've read over this document with your attorney.
Yes, sir.
And has anyone threatened, forced, or pressured you to make you feel like you had to waive your right to a jury trial?
Yes, sir.
All right, Mr. Biggs, you explained the waiver of jury trial to Mr. Truitt and Lady Sanson. You join that. Ms. Heisel, I see, has joined on behalf of the state, waiving the state's right to a jury trial. So the court will find that the defendant has been admonished as to his right to waiver of jury trial. The court hereby approves that, finds that Mr. Truitt has waived his right of jury trial freely, intentionally, knowingly, and voluntarily. Court will reset Mr. Truitt for plea before the court. And Mr. Biggs, are you available? The dates that I've got presently are April 14th. That'd be the next time. That's a little over 30 days. What about April 26th? Okay, and will this be a plea to tie or probation? Probation, okay. So we'll set Mr. Truitt then to enter his plea before the court April 26th at 9 a.m. Even though Mr. Truitt is intending on pleading, I'm going to also sign his conditions of pretrial release today. So he'll need to meet with the pretrial release officer. You're going to get this yellow copy and then come back here and meet with Officer Burns, and she will go over this paperwork with you. You're going to have to report being in compliance with your pretrial release. Those will be attached to your bail in this case. So if you test positive for alcohol, drugs, commit another offense, fail to report as ordered, then your bond can be found insufficient even while you're waiting to enter your plea. All right?
Right about that, Your Honor.
That's good. All right, so you sign that yellow copy and then come back here and meet with Ms. Burns. Cameron Martin. All right, this is cause number CR 2260, State versus Cameron Dale Martin. Mr. Martin, if you'll raise your right hand, sir. You swear that the testimony you give to the court today would be the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. All right, Mr. Knoll, can you move out of the way, please? Thanks, sir. All right, Mr. Martin, are you a United States citizen? Yes, sir. Do you read, write, and speak English? Yes, sir. And have you ever been diagnosed with any type of mental condition? No, sir. In this case, you are represented by your attorney, Mr. Bingham. Oh, Mr. Bingham did the switch on me there.
Yeah.
All right, sorry about that. Sorry about that, Mr. Bingham. Are you pleased with Mr. Bingham's representation of you? You feel like you got enough time to discuss the case with him, have all of your legal questions answered? Is there anything about this paperwork that you've read and signed today that you do not understand? And I see here that you are waiving your right to indictment in this case and allowing the state to prosecute you without taking the case to the grand jury. Is that your understanding as well? You understand that you have the right to have this case presented to the grand jury for them to determine whether or not there's sufficient evidence or probable cause to go forward on this case. You understand that? Yes. You understand by waiving that, you're allowing the state to file an information in this case and prosecute you without going through that grand jury process. Yes. And you've discussed this waiver with your attorney, Mr. Bingham, is that correct? Yes. And you understand what you're giving up today? Yes, sir. And I see here that the proposed plea agreement is that you would plead guilty by information to a first-degree felony offense of manufacture or delivery of a controlled substance, penalty group 1, greater than or equal to 4 grams less than 200 grams, that being a first-degree felony, which carries a range of punishment of not less than 5 years or more than 99 years or life confinement, and an optional fine not to exceed $10,000. Do you understand that as well? Yes, sir. Mr. Bingham, do you believe Mr. Martin to be competent today?
Judge, we've met with Mr. Cameron, spoken to him on many occasions. We reviewed the evidence of the case, discussed the law applicable to the case. There's no question he's competent. He's able to assist in the preparation of any defenses we may have pursued. We felt like in this case, the best resolution was the one that we reached. He understands what's going on in his company.
And you've explained to him all of his legal rights with regards to the case and specifically the waiver of indictment.
We've told him that he has a right to have this case presented to a grand jury. The grand jury could no bill it, they could true bill it. However, the offer that we've had may or may not be there if you went to a grand jury. In this case, he's elected, he knows we're waiting any 10 days to prepare, and we've elected to go forward on the information. In this case, he's aware of his rights.
All right. Court will find that Mr. Martin has been admonished as to his right to indictment by grand jury, and that he has intentionally, knowingly, voluntarily waived that right today. And the court will approve the prosecution proceeding on information.
One of the things, if I may, that we're hoping for is that he could enter his plea today, come back for sentencing. Mr. Martin, this is not we appreciate the DA's office. They've discouraged what we've dealt with. She has gone out of the way to work with us on this case. It's not the date of offense a little while back, but Mr. Curry's been working with us throughout that. We finally got to this resolution. In the interim, Mr. Martin's stepfather had a stroke out of state. They brought him back to rehab facility here. Cameron's mother is the one that watches his children. So they're in the process of trying to coordinate the rehab and co-watching his children. We wanted to come in and let the board know it's going to be a plea. We intend to accept 8 years. We're very grateful for that. But we were hoping to set it off 2 days so they can get in a routine where the mother's able to work with the father at the rehab facility, and he has arrangements for his kids when he goes to prison.
So the report date would be Saturday.
Whatever the court says, yeah,
Did you say 2 days or a few days or what did you?
2 weeks. We're hoping for a judge. I'm sorry.
That's right. Is
And
this part of the plea agreement?
we've mentioned this to Mrs. Curry, but I think she's leaving this up to the court. I don't know that they're for it or necessarily against it. Mr. Martin's been available to us. We don't believe he's a risk of flight. He knows that 8 years is a lot different than life. And but I'll also tell the court he has prior felony convictions. He was on parole, he completed the parole. We believe I just didn't know if the court wanted to wait to impose sentence to come back for a sentencing hearing or actually enter the 8 years. We were hoping, how we wanted to do it, we just were hoping to get the two. One of them is more of a furlough and the other's and I know a lot of courts don't want to do that. So we hope just to reset the sentencing. Knowing he's pled today, we believe he'll be here. And he wants to take care of it. He just have his 2 weeks to coordinate.
Sure. And my policy is, unfortunately, because I've been in this situation before and had individuals not show up when they're supposed to, is we either plea and he goes into custody today, or we don't plead today. He can file a waiver of jury. That way, if he absconds, decides that he doesn't want to go in, then that offer can be revoked and the court's hands are not tied or punishment capped at 8 years. So I'll let him make that decision whether he wants to go today or, and I understand this is an information, so I'm not saying that. I'm saying if you want me to accept it and do the paperwork, he'll need to go today, but otherwise he's waived indictment, he can waive jury trial, and we can reset this for a plea later. I have no problem with that.
Yeah, what's that?
Absolutely. It's not too much.
We'll execute that waiver of jury trial. I hope that's okay with the state. We'll do that if reset it for.
Okay.
So just do that.
So I'm going to retain the waiver of indictment. I'll have that filed. I'm going to return the plea papers to the state. And you said 2 weeks, so we can come back either on March 31st. That would be 3 weeks. That would be the next criminal setting, or we could do April 14th.
Check with.
Yes, go ahead. So 3 weeks on the 31st or April 14th would be 5 weeks.
See, I'm jury trial on those.
He's over here.
Right. Are you?
So we'll take the 31st.
Okay. All right. Court will set Mr. Martin to enter his plea before the court. And are we going to do the waiver of jury trial? Yes. Okay. We'll go ahead. We'll set him on March 31st. we'll set that at, set that at 1:30. The jail docket will be over here in the courtroom on 1:30, because that's an evidentiary day. So we'll just squeeze this plea in. And so you'll go over that waiver of jury trial with the client, and then I'll work you back in once I start going some other cases. Mr. Biggs, are you ready on Vasquez? All right. Are you on that case, or is Mr. Biggs on that case? Okay. Aaron Vasquez. Mr. Vasquez, if you'll raise your right hand, I'm going to place you under oath. Mr. Vasquez, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Yes. All right, you may put your hand down. You are Aaron Vasquez Jr., is that correct? And Mr. Vasquez, are you a United States citizen? Yes, sir. Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorneys, Mr. Matt Bingham and Mr. Kenneth Biggs. Are you pleased with their representation of you? Yes, sir. You feel like you had enough time to discuss the case with them and have all of your legal questions answered? Yes, sir. Is there anything about the paperwork that you've read and signed today that you do not understand? And where you sign these documents, is that your true and correct signature? And did you only sign that once you understood what you were signing? Yes, sir. Mr. Biggs, do you believe your client to be competent today? Can you explain to him his legal rights? And did you also explain to him the advantages and disadvantages of a deferred adjudication plea? You believe he understands it? All right, I see here, Mr. Vasquez, that you're charged by indictment with a third-degree felony offense of online solicitation of a minor. That being a third-degree felony carries a range of punishment if convicted and sentenced between the range of punishment of not less than 2 years or more than 10 years confinement in the Texas Department of Criminal Justice, and an optional fine not to exceed $10,000. I see that the plea agreement is that you would be pleading guilty to that charge. The state would be recommending that your guilt be deferred. That means that you would not be convicted of this offense upon your plea of guilt, but rather you would be placed on 10 years community supervision in order to pay fine, court costs, and reimbursements. Is that your understanding of the plea agreement? And you understand, Mr. Vasquez, if the court approves this and places you on deferred community supervision, if during the period of your community supervision you violate any one of the terms or conditions, that the state could file a motion to adjudicate your guilt. That means to convict you. They could schedule you back before the court. They could put on evidence. If the court finds that the evidence proves that you violated any of the conditions of your community supervision, the court could revoke your community supervision, could convict you, and could assess your punishment anywhere between 2 years and 10 years. Understanding all of those things, do you still wish to go forward? Yes, sir. All right, Mr. Vasquez, I'm going to ask you at this time, how do you plead to online solicitation of a minor at third-degree felony? Mr. Biggs, did I ask you if you believe your client's competent today?
Yes, Your Honor, we've had multiple opportunities to discover the case, the consequences of this specific charge, including several conversations about the consequences of this plea, specifically with respect to the registration requirements. I'm confident that not only does he understand part of it, but the consequences of entering the plea are specific to the time.
Thank you, Mr. Biggs. Mr. Vasquez, are you pleading guilty to this crime because you are guilty of committing the crime?
Yes, Your Honor.
Has anyone threatened, forced, or pressured you to make you feel like you had to plead guilty to this crime today?
No, Your Honor.
All right, the court will accept the defendant's plea of guilt. Mr. Biggs, is there any objection to the state's evidence?
No objection, Your Honor.
All right, the court admits state's evidence and also takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, I don't have victim notes on this, but I believe we are in compliance with no response back.
So, Mr. Biggs, I need your client to sign the admonishments as with regards to sex offender, and then here, chapter 62 needs to be given. Yeah, so
Correct.
yeah, he
We
needs it.
corrected this document.
Yeah, he needs it. Okay, you do.
I have the corrected version.
Okay. You may. 62.
It's a 10-year registration requirement, so we can fix that.
All right, I want the record to reflect that I'm tendering to you a copy of chapter 62 of the Texas Code of Criminal Procedure for presentation to Mr. Vasquez.
DA's office is provided these documents. Thank you, Mr. Biggs.
All right, is there anything further from the defense? All right, take just a moment to review the evidence. All right, the court reviewed the evidence. I do find there is sufficient evidence to convict Mr. Vasquez of this offense. However, the court will follow the plea agreement in this case. The court hereby defers a finding of guilt, places Mr. Vasquez on 10 years community supervision, orders him to pay a $2,000 fine, $290 court costs, $35 reimbursement fees. Court is also dismissing under section 1245 of the Texas Penal Code, cause number CR 21395, possession of child pornography. All right, Mr. Vasquez, you hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm going to have you step forward to be fingerprinted with the deputy here. After that time, step over here to your left to Officer Burns. It should give you more information. All right, Cameron Martin, if you'll step back up, please. All right, back on the record, CR 2260, State versus Cameron Dale Martin. Mr. Martin, I believe I've already sworn you in. Is that correct? All right, Mr. Martin, so now you have filled out a document called Waiver of Jury Trial with your attorney, Mr. Bingham. Did you read over this document? Do you understand that in this document, you would be giving up your right to a jury trial in this case? You understand that once you waive your right to a jury trial, it may not be restored to you at a later date. It means if you change your mind here in a week or two, you decide you don't want to enter into that plea agreement, the court could proceed on your case without giving you the right to a jury trial. And in reading this, you understand that you're the only one that can waive your right to a jury trial. And are you doing that today because you want to do it? Has anyone threatened, forced, or pressured you to waive your right to a jury trial? Right, court will find that Mr. Martin has been admonished as to his right to a jury trial, that he's intentionally, knowingly, voluntarily waived that right. The court approves the waiver of the jury trial, finds that it is joined by the state of Texas and also by defense counsel. The court will set Mr. Martin to enter his plea before the court on March 31st at 1:30, and I'll be here in the courthouse.
Judge, thank you so much.
Thank you for being here.
May I be excused?
Yes, sir.
Thank you.
All right, counsel, who's next? Good one. Remind me your name, sir. Jarvis. Okay, there we go. All right, this is cause number CR 21160, Guadalupe Bahina. right, Ms. Bahina is set for arraignment today.
Yes, Judge, we have reviewed the document, or the document is incorrect on the name. The middle name, Brito, needs to be removed.
So that's not a name of hers at all.
That's correct.
All right, and does she waive the formal reading of the indictment?
She does, Judge. She won't wear it.
All right, and how does she want to enter her plea?
Not guilty.
All right, the court will find that Ms. Bahina has waived the formal reading of the indictment in this case and the formal requirements of arraignment. The court will enter her plea of not guilty into the record, and we will set this for pretrial hearing. Are you available, either one of you, on April 14th?
Six CBDs today.
Give you April 26th. All right, so we'll set Ms. Bahina then for pretrial on April 26th. That's at 9 a.m. State, is there a motion to amend the indictment?
Yes, Judge, at this time, we make an oral motion to amend the indictment to strike through the middle name of Ms. Bahina, that's Brito, shall be struck from the indictment. Yes, the court to do that.
There being no objection, then the oral motion to amend indictment is granted. Court will have the original indictment redacted to reflect the spelling, the correct presentation and spelling of the name of Guadalupe Bahina without. All right, so Ms. Bahina, once you sign and get the yellow copy, then you'll be free to go, okay? Debbie Spriggs. Morning, Your Honor. Come on, just look how you said. Good, how are you? Mr. Biggs, can I have y'all kind of? All right, this is CR 21-372, State versus Debbie Renee Spriggs, and we are set for pretrial today.
We are, Your Honor. I'm asking for this. Set the schedule for another pretrial date. Last time we were here, we picked up a large amount of DVDs, reports, et cetera. I have had a chance to go through those somewhat, not all of them yet, but have not had a great opportunity to sit down with some Briggs and talk to her about those DVDs. Nor have I had a really good opportunity to talk to this about this case, how to see that going forward. So, I'd like to have another pretrial date, because I believe that I can have that all done by the time we come back next time. Hopefully have a bit better.
No objection, State.
There being no objection, the court will set Ms. Spriggs. You available on April 14th.
Judge, I'm sorry, I couldn't hear the date.
Well, I'm asking about April 14th.
Is that in the morning, Your Honor? That would be in the morning.
That would be in the morning, yes.
That'll work for me.
Okay. Then the court sets Ms. Spriggs for additional pretrial hearing April 14th at 9 a.m. Ms. Spriggs, once you sign and get the yellow copy, you're free to go.
Thank you, Your Honor. That's all I have.
Good to see you. All right, Mr. Rush. Just one today, Stephen Cross, CR 27, CR 20-7. All right, Mr. Cross is set for pretrial.
Yes, sir. He's set for pre-trial. I'm gonna need about 30 more days. I'm trying to look into get some documents from another jurisdiction. I should have them pretty quick, but I don't have them right now. As the court said it, I believe the date answer the 12th and 14th. I'm gonna be here for sure on the 12th already. So if your docket's clear on that, I don't really matter.
Yeah, we're maxed out on the 12th.
14th 's fine.
14th. Any objection from the state?
No, Your Honor.
All right, there being no objection, the court will set Mr. Cross for an additional pretrial hearing on April 14th at 9 a.m. Once you get the yellow copy, you're free to go, but I do want you, Mr. Cross, to report down to the court collection office. I show that you're about to be pending a warrant on one of your previous cases where you've not been paying your fines and court costs, right?
I'll do that. All right, see you Saturday.
Thank you, Mr. White.
Thank you, sir.
Now serving White number 2.
Actually, this gentleman.
I just call y'all as I see y'all standing there, so you gotta make your way to the front. Remind me your name, sir. Tyra. Yes. All right. All right. Jamie Johnson, CR 21295. Ms. Johnson is set for pretrial today. Mr. Tyra, do you have any contested pretrial motions, any issues with discovery?
No contested issues at this time, Judge. We've got the discovery on the portal. I did get some discs as well. Some of the discovery on the disc did not work, so I'm going to go over after we get done and try to pick up on a different form, maybe a thumb drive or something to that extent. The discovery that we have is pretty voluminous. I've met with Ms. Johnson several times. We've gone over a good portion of it, but we still have 5 minutes to finish. So I would ask that we set this another day out for pre-trial. So
Any objection from the state?
No, Your Honor.
Do we know if there's a reoccurring issue with formatting of, I keep hearing this being a common response. Is it user application or is it a download application? It seems to be the same thing, that they're not able to access the discovery.
Yeah, I'm not sure, Your Honor, if it's, I'll ask Ms. Melton in our office who handles the disc discovery if it's consistently a WatchGuard issue. I don't know if it's a consistent program or if it just depends on the disc. I know that.
Mr. Tyler, can you explain to me when you try to get into your discovery what's occurring, and maybe that'll help them out?
Well, the problem that I had was, in speaking with Ms. Melton, my staff, they copied information that was on a thumb drive onto a CD, and apparently that didn't work. So I'm bringing the thumb drive over to see if I can get that information.
So like
that's the problem I had.
So when you put the CD, what kind of program are you using to try to access it?
It was just a data CD with photographs on it, and the CD was blank.
So it wasn't a video, it wasn't a VLC type issue or WatchGuard issue, it's actually just
It's just
JPEG or something.
That's correct. Just photographs, I guess information that's on the thumb drive that the state had. So
Yeah,
Judge,
just ask Ms.
that's different than what we've heard before, so I acknowledge you being what it is. We'll keep looking for systemic issues. That doesn't sound like that's part of that, but we'll keep looking and see if we can try to get that ironed out.
Right, are you available on April 14th?
in the morning or the afternoon?
Morning. Yeah, we do our bail fines in the morning, jail in the afternoon.
Yes, sir. I can do that.
All right, then, how many discs have you not gone through yet that you've had those issues with? Just wondering if I should be more time,
There were 4 to 5, maybe.
that you haven't accessed.
That's correct.
What about April 26th?
It's like I can do that.
Would you prefer to do that so you have one more time?
Yes, sir.
All right, let's separate out a little bit further then, a couple extra weeks. And we'll do April 26th for pretrial. And that will also be at 9 a.m. Ms. Johnson, once you sign and get the yellow copy, you're free to go.
Yes, sir. Thank you.
Thank you, sorry. Right, ready?
Yes, sir. I don't have to as the CR 12, 169.
Okay, have you filed a letter of representation, or we just not put it on the docket yet?
It's, I've got a copy of the file letter.
Okay, no, that's fine. I'll just, as long as you follow it with the clerk, then I'll have our document.
At this point, Your Honor, I haven't really had any time. I just got hired on since.
Yeah, that's fine.
Very much time.
Well, I think we were set today, on a status to hire attorney. So, Mr. Lindbergh here. All right, yeah, I believe that we had set this, for Mr. Landenberg to hire an attorney, so you're here.
Okay.
That's good news. So we'll reset this, and I will set it on the contested docket on April 28th. That'll give you time to determine if y'all can resolve the case, and if not, then we'll just move forward with contested hearing on that. So just to bring some other issues with your client to your attention, he has several delinquencies on older cases, in addition to his motion to revoke issues. So it might be something you want to approach with him.
All right.
Austin, you ready? Yes. Adrian Serta, CR 21381.
Discovery on the case, offer from the state. Drove over last week to get the videos, they do work. I had a chance to look through them.
It's good news.
I have not had a chance to look at it. I'd like to pass it to.
No objection. Say.
All right, there being no objection, court will reset pretrial to April 14th at 9 a.m. Mr. Austin, I am going to have your client sign conditions of pretrial release. Just, okay, if not, just make sure that the pretrial release department probation officer is good to go. And if they're good to go, then we'll see you back on April 14th. And once you get that yellow copy, then you're good to go. Meet with them, okay? And Mr. Austin, Ms. Burns said your client's good to go, that they have signed the conditions of pretrial release. Mr. Noel, you ready?
This is on Theodore Houston.
Mr. Houston?
Page 5. Mr. Houston,
This is CR 212647, Dr. Cole. Go ahead. Mr. Noel.
Been out of the hospital less than a couple of weeks. I don't know, maybe a month ago, maybe more than that. I got a text message that he was in the hospital in Dallas. I had some medical records, they indicated maybe offer might change depending on some medical issues. Gonna get those records. Ms. Heisel, if HUS, some sort of autoimmune disease, and we're gonna get those records to the state. It's on dialysis present. We'll get those records to the state over the next couple of weeks. That may help resolve this case. I had talked with him in at least a month because he'd been in the hospital and I hadn't seen him until today.
All right, court will reset. Mr. Houston, are you available April 26th or 14th?
16th, sorry, 26th, I think it's gonna back on the other case.
Okay. Then we'll set Mr. Houston for docket call on April 26th at 9 a.m. Mr. Houston, once you sign and get the yellow copy, you're free to go, sir. Sanders, who are you ready?
Scotty Penny.
Scotty Petty, CR 21-365. Remind me what you said.
It should be pre-trial. I think we set for pre-trial last month, to be sick, so. If we have pre-trial issues.
All right, there being no pretrial issues, the court will set this docket call. You're available April 14th.
Yes.
All right, court sets Mr. Petty April 14th at 9 a.m. And Mr. Petty, once you sign, you'll get the yellow copy. You're free to go. Mr. Petty was not on the docket, so you wouldn't know the review, no conditions of pretrial release. I don't know if you want to. He's the original. And ask all. Yes, Mr. Petty, I want you to check in with pretrial release, just because you weren't on the docket, so they didn't know to review your file today. So if you'll do that, if they have no issues with you, then you're free to go, okay? All right, are you ready on Little John or Robinson?
Little John.
Braley Littlejohn, CR 2231. Ms. Littlejohn is set for arraignment.
Yes, correct. And Judge, we've gone over the indictment. Her name is spelled correctly. We discussed the level of offense, the punishment range on that. We waived the reading indictment, waived the formalities of arraignment, and enter a plea of not guilty at this time.
All right, the court will find that Ms. Littlejohn has waived the requirements of arraignment, and the court will enter her plea of not guilty into the record. We will set this for pretrial hearing on April. Do you want to set this one also on April 14th?
That's
Does that give you enough time?
Yeah.
All right, we'll set Ms. Littlejohn for April 14th, and Ms. Littlejohn will have conditions of pretrial release that she'll need to sign today. So once you sign this form and get the yellow copy from Mr. Sanders, then report over here through these doors, or actually have a seat out here, and then they'll come out and they're going to give you conditions of pretrial release. You have to report, make sure that you're going to drug test, do things of that nature. Okay.
Thank you.
You're welcome. Charlotte Robinson.
Judge, she's the one that's.
Oh, yes. Okay. Yeah. We'll go ahead and call it anyway. But CR 21367. Is there any objection to Ms. Robinson not being here due to the next recovery center?
No, you're not.
Okay. We'll reset Ms. Robinson then for docket call on April 14th at 9 a.m. Okay. So your business on the morning docket?
Yeah, well, it's 11:30, please.
Oh, that's right. That's right. Mr. Adams, are you ready on anyone? Who'd you like to call first? Whoever's in top. Josie Bohannon. She wasn't here earlier. I called her name, not she wasn't here. Okay. Nicholas Crouch. He wasn't here either. That may explain why he's not here. You know what he's there on?
I read it myself.
Yeah, maybe refresh on it.
Right, are you Joseph Howell? Cause number CR 2226, State versus Joseph Michael Howell, set for arraignment.
Good morning, Your Honor. Yes, on behalf of Mr. Howell. Mr. Howell and I have reviewed the indictment in this case. He advises me that his name is properly set forth and spelled in the indictment. He understands the allegation that's brought against him in that indictment. We are entering a plea of not guilty, waiving the reading of the indictment. We would ask the court to set us for a pretrial hearing.
All right, the court will find that Mr. Howell has waived the formal requirements of arraignment. The court will enter his plea of not guilty into the record, and we will set this matter for pretrial hearing. I'm sure, see, I think I've already set you the date for anything, so the date will be available this time, April 14th and April 26th,
26, Your Honor.
whatever you're available for.
He lives in Killeen, so that extra time that would to make a travel arrangement might benefit.
All right, court will set Mr. Howell for pretrial hearing April 26th. That will be at 9 a.m. Once you sign and get the yellow copy, Mr. Howell, you're free to go.
Are we gonna be able to zoom in from the county?
At 1:30. Yeah, he should be the first one Zoom this afternoon. I don't have any notes on free trial with Mr. Howell, so I believe he's good to go. Yeah, it's Chastity Smith here. Chastity Renee Smith, going once, going twice. So, okay. All right, so I'll have her name called in the warrant issue.
It's not a very good record.
You make it up later.
Your Honor, I think I'm on your afternoon docket. It's still there.
Yes, Ms. Abraham's gonna try to work out the logistics on the Zoom and she kind of fine. Mr. Adams, I'm gonna recall Mr. Crouch. We're gonna have to reset it. They're not gonna be able to do it. As the county said, the only time they can do it would be at 12 o'clock. All right, so on the record, CR 2210, 10, 11, 12, 13, State versus Nicholas Scott Crouch, set for arraignment. Court finds that Mr. Crouch is incarcerated, so the court is going to reset his arraignment for April 26th. And that'll be at 1:30 if Mr. Crouch is incarcerated, 9 a.m. if he's not. Of course, court will accept a waiver of arraignment for that time.
Plenty of time to go see him. Like every effort to get some waiver.
Yeah, they said they're completely full. The only time they had available was right at noon, and I was afraid that may run long.
I'm jealous of my
Me as well. Here, so. You see if, Karen, you see if Karen needs probation inspector. I'm looking for paperwork. On probation extension. Usually it's right here. Doesn't see it. Keeps doing her away from the judge. Huh? It keeps going her away from her. That's okay. That's okay. She's probably getting a lot of stuff from that resolved for me by working with you, so. She's doing a great job. She's happy. I didn't like this one.
See. She's gonna sign. Go ahead.
Letitia Hill. Miss Hill, I'm just coming around. All right, are you Letitia Renee Hill?
Yes, sir.
All right, Miss Hill, this hearing is for an extension to your community supervision period. I see here that you're asking the court to allow you to have your probation period extended for 2 years, which you're set to expire here in about 5 days. And this extension would extend you until May 14th of 2024. I also see though that if your probation period is extended, probation department is asking that you not be required to pay probation fees or UA fees during that extension period. Why is it that we need to extend your probation?
In the process of me, after the long service, I hadn't had a job in about a year. And I just been trying to maintain the bill. And whenever I could see my fees or this community service, I tried. Just asked it. Right now, I just had back surgery, so I probably won't be able to look for a job probably for the next month. And I can't lift over 10 pounds, so I try to look for a job where I won't have to require much lifting, but due to what's on my record, it's kind of hard.
Sure. So let me ask you this, Ms. Hill, if I were to extend your probationary period for an additional 2 years, do you believe that that would increase the likelihood that you would successfully complete and get everything done that you need to get done?
I believe I can be someone that's on my side is really to really get my needs in.
So if I extend it today, it would help you avoid being revoked in the next 5 days. Is that right?
Yes.
All right. So you're asking me to extend you for an additional 2 years. All right. All right. The court's going to approve the amendment to Ms. Hill's community supervision. The court will grant the extension period. The court will extend her community supervision in both cause numbers CR 18147 and 146 for 2 years with a new supervision expiration date of May 14th of 2000. Ms. Hill, I'm going to give this to Ms. Burns. Go join her. She's going to have you sign. We get more information. All right. Good luck on your job hunt. Hopefully you find something. Yes, thank you, Mr. Noel. Jennifer Gonzalez here. Mr. language. Don't mark it down. Lonnie Jean Richardson here. Is Josie Bohannon here. Chastity Smith here. Jeannie Hughes. Misty Backus. Okay, you are working on it. Thank you. All right, we'll be with you in just a moment. Joshua Holloway here. Chester, are you ready?
Yes.
No, it's okay. I know you're working. I've seen it. So I've been fiddling your thumb and all that. So any certain order you want to go?
No.
Let's go down the list. Houston Carpenter. CR 17442.
Mr. Carpenter has accepted the state offer. We said have time to get before that. We should set this out like we judged.
Okay. Will it be to time or probation?
No, it's going to be a time served and then he'll have court costs and everything get paid on.
He won't need to go into custody. All right. Are you available on April 14th?
Potentially $14 7.
You want to get out of it? Give me a motion for continuance. I could do that. Not sure to carry anyway, but I could give you entry for your motion for continuance.
Perfect.
Let's see. April 26th. All right, Mr. Carpenter, I'm going to set you to enter your plea before the court April 26th at 9 a.m. I do show Ms. Chester that Mr. Carpenter is delinquent $215 on his pretrial. If that's not resolved prior to that date, plea may get rejected. Jackie Elliott, CR 21323. Ms. Elliott is set for pretrial.
Yes, at this time, we have no contested pretrial motions. We were in talks with the DA about a deal and it's just been changed, altered a little bit, so we're asking for on the docket policy, yes, time to think about it, but that's not, we're trying to get that answer to the DA's and decides complete.
Court will set Ms. Elliott then for docket call on April 26th. Ms. Elliott, I show that you're delinquent $180 on your pretrial supervision.
Yes, actually, for my misdemeanor, I have 100 for it today. I'm gonna pay on my way out. And like I just told my lawyer, I got a full-time job now, salary starting tomorrow. So by the time I come to court next month, I should have everything, if not paid for, caught up.
Great, thank you, Ms. Elliott. I appreciate that. If you'll make that payment today. Mr. Enox. CR 21-324. Mr. Enox is set for docket call.
That's correct, Your Honor. We're asking for one more docket call. We were talking with the state and there's some potential mitigation that we're gonna try to offer to the state, based on the plea deal that we got. Ask for another docket call setting.
All right, there being no objection from the state, court will set Mr. Enox for docket call on April 26th. Mr. Enox, I showed the same issue with you that you're delinquent $390.
Yes, sir. I made a payment last month and I am leaving here and making a full payment. I will have to
A full payment?
Yes, sir.
Good. Mr. Hamner, CR 21-358. Mr. Hamner is set for docket call.
Yes, we have been talking about the state's offer. It's our understanding that it's not changing. This is a case I took up from Ms. Beasley, so we're trying to make sure that I was in this negotiation. So we asked for another docket call, so he has time to make that final decision on whether to be clear.
Any objection from the state?
No, Your Honor.
Being no objection, court will set Mr. Hamner for docket call on April 26th. That will be at 9 a.m. Once you sign and get the yellow copy, Mr. Hamner, you're free to go. Christopher Nash. CR 21-388, set for pretrial.
No contested pretrial motions or matters at this time, Judge. I've relayed the offer to Mr. Nash. We're going to see if we can talk to the state, have some mitigation or some information on where to just ask for a docket call.
All right, court will set Mr. Nash for docket call April 26th, 9 a.m. Once you sign and get the yellow copy, you're free to go. Thank you. You're welcome. Ms. Backus? This is cause number CR 21158, State versus Misty Backus, set for docket call. Mr. Mayor.
Yes, Judge. We were on the path, we had had a plea agreement reached back in September of last year. Some stuff had come up in the subsequent settings, not all my client's fault. Last setting I was out due to baby. Prior setting was due to Ms. Backus being sick with COVID. At this point, we're going to request an additional docket call. I'm working with the state, provide them some new evidence that may change the disposition of this case. And we would ask for one additional docket call, a final docket call, before we dispose of the case one way or the other.
Join Mr. Manning's, provide some evidence, kind of next thoughts for us. Have a final decision by the next time.
All right, Ms. Backus, I show that you were late today. Court starts at 9 o'clock. I work very hard to start court at 9 o'clock because people like you expect me to be here. People like me expect you to be here. So I'm going to grant the request, but I am going to UA you today. And if you're positive, you're going to stay with me in the county jail. If you're negative, then you'll go home until you're available on April 14th.
I believe so, Judge. Yes, I believe I'm previously set on April 14th.
All right, so I'm going to reset your docket call regardless to April 14th. So you're going to sign this notice of setting, get the yellow copy, and then come over here and meet with Ms. Burns, and then don't leave until I tell you.
Sorry, Judge. I apologize. The April 14th case that we had previously was set to the 12th. I'm in Henderson County. Can I set her on the 12th on that with my other cases?
April 26th.
April 12th, I have Mr. James Johnson and Ismael Rodriguez.
Yeah, we're full on we're nearing 80 cases on 12.
Okay. If I could appear a little bit later on the 14th, I'll be in Henderson in the morning.
What about the afternoon?
Afternoon is clear.
Let's wait and see how our drug test goes before we know if she's in the morning or the afternoon.
Sounds good. I'll put down the 14th.
All right, 14th, and then just hold up on the time. All right, Ms. Backus, come over here and see Ms. Burns. This is cause number CR 21158, State of Texas versus Misty Backus. The board has already heard Ms. Backus's announcement on the setting today. We reset Ms. Backus to April 14th. Court has ordered that Ms. Backus be tested for her compliance with conditions of pretrial release. Ms. Williams, have you conducted a urinalysis exam with Ms. Backus?
Yes, I have. She submitted a urine sample and it was positive for marijuana and methamphetamines. A letter was provided from a doctor out of Houston that she has a prescription for the marijuana, and she admitted to smoking methamphetamines on March the 7th. And she signed a UA option.
Ms. Backus, you're well aware that using methamphetamine is a violation of your conditions of pretrial release. All right. Based on that admission to using methamphetamine, the court's going to find that you have violated the conditions of your pretrial release. The court is going to find your bail to be insufficient at this time. The court's going to revoke your bail, issue you bail at $75,000, and order you into custody. If you please, if you'll take Ms. Backus into custody.
Is that her father that was with him? Significant.
All right, y'all ready, Mr. Skinner?
Because I'm like,
Well, you can go ahead and bring it.
we gotta cut his monitor. Let me find some
Scissors.
We gotta cut Skinner's monitor off.
This is the individual Carl was just talking to me about. Cause numbers CR 2065, CR 2226, State of Texas versus Travis Lee Skinner. Mr. Skinner, where you're at, if you'll raise your right hand, I'm going to face you under oath. Mr. Skinner, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, get your hand down. Mr. Skinner, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jeff Sanders. Are you pleased with Mr. Sanders' representation of you?
Yes, sir.
Like you've had enough time to discuss both of your cases with him, have all of your legal questions answered?
Yes, sir.
Is there anything about this paperwork that you've read and signed that you do not understand? Any questions about any of the paperwork, any of your legal rights?
Sure.
And your signature as it appears in these documents, is this your true and correct signature? And did you only place your signature here once you were confident you knew what you were signing?
Yes, sir.
Mr. Sanders, do you believe Mr. Skinner to be competent today?
Yes, Your Honor.
And have you explained to him his legal rights with regards to his cases? And also, have you explained to him the advantages and disadvantages of a deferred adjudication plea?
Yes, Your Honor. That's what matters.
And you believe he understands all of those?
Yes, I believe it does.
All right, Mr. Skinner, in cause number CR 2065, you are charged by indictment with a second-degree felony offense of sexual assault of a child. A second-degree felony in the state of Texas carries a range of punishment of not less than 2 years or more than 20 years confinement in the Texas Department of Criminal Justice, and an optional fine not to exceed $10,000. In CR 2226, you're also charged by indictment with a third-degree felony offense of bail jumping, failure to appear on a felony. A third-degree felony in the state of Texas carries a range of punishment of not less than 2 years or more than 10 years confinement in TDC, and a fine not to exceed $10,000. Do you understand the range of punishment applicable in each one of these cases?
Sure.
I see that the plea agreement that exists between you and the state with regards to the sexual assault of a child is, upon your plea of guilt to that charge, the state's recommending that a finding of guilt be deferred. That means that the court accept your plea of guilt but not convict you on this date, and that you be placed on 10 years community supervision with payment of court costs and reimbursement fees. Is that your understanding of the plea agreement in that case?
Yes, sir.
And you understand, you also understand that by pleading guilty to that type charge, it would also carry with it lifetime requirement to register as a sex offender.
Sure.
With regards to the bail jumping, it appears that you would plead guilty to that charge in exchange. The state's recommendation is that you be punished by 10 years confinement in the Texas Department of Criminal Justice, payment of a $2,500 fine plus court costs and reimbursement fees. And in that case, you would receive 35 days credit towards that sentence for the time that you have already spent in jail on that cause. Is that your understanding of that plea agreement?
Yes, sir.
And is this plea agreement to take effect today with Mr. Skinner going into custody?
Immediately, Your Honor, yes.
All right, Mr. Sanders, has the court correctly stated the plea agreement in each case?
Yes, Your Honor.
All right, so at this time, Mr. Skinner, I'm going to ask you, how do you plead to sexual assault of a child?
Guilty.
How do you plead to bail jumping and failure to appear on a felony?
Guilty.
Mr. Skinner, are you pleading guilty to each one of those crimes because it's true that you have committed each one of those crimes?
Sir.
Has anyone threatened, forced, or pressured you to plead guilty to either one of these charges?
No, sir.
Court will accept the defendant's plea of guilt in each case respectively. Mr. Sanders, any objections to the state's evidence?
No.
All right, state's evidence is admitted. The court does take judicial notice of the defendant's judicial confession. Is there anything further from the state? And I would like to hear about victim notification and compliance.
Yes, Your Honor. The victim, Caroline Graham, is here with us in court today. I believe the court has already received her victim impact statement and signed off on the tracking sheet for that. Ms. Graham would like to make formal allocution after the pronouncement of sentence and having Mr. Skinner taken into custody.
And the victim and the victim's family has been consulted about the terms of these plea agreements, and they are supportive of the court entertaining these and accepting these. Is that correct?
Yes, Your Honor.
All right. Anything further from the defense, Mr. Sanders?
Judge, just a couple of things. I think for the court review, the police report, this is something that, one of the legal issues I talked a lot with Travis about was that there was another individual involved who also ended up taking his life, and so was not ultimately prosecuted. But we talked about how with different acts mentioned and explained in the police report, even if Travis didn't commit every single act, a person can still be criminally responsible for the act of another if he's participating, assisting, that sort of thing. So I think he understands the whole concept of criminal responsibility. And so that was one factor we talked a lot about. And just to clarify with the probation, this was a question he had. I told him I'd just clarify with the court that since he'll be taken into custody and being sentenced to TDC on the bail jumping, that the different the timing requirements on the probation conditions, that those things wouldn't go into effect until after he was released. As far as he's not going to get any kind of violation of probation while he's in TDC. So
That's correct. That's my understanding that the probation department is aware that the probationary period could not legally begin until Mr. Skinner is in a position to be able to comply.
And he knows then to, as soon as he is released on parole, to immediately report to Vincent County Probation.
Okay. Anything further?
No.
All right, take a brief moment to review the evidence. Seisel, I noticed that in the indictment, it's a 2-count indictment, but it appears that count 2 may be duplicative. It's struck out. Is there any notation on it for the record?
Your Honor, for the record, the state is abandoning count 2 just to streamline the paperwork. We are not asking to stack at this time, so we would be abandoning count 2. All right, the court has reviewed the evidence. I do find sufficient evidence to convict Mr. Skinner of each one of these offenses. Court will follow the plea agreement reached between Travis Skinner and the state of Texas. In each case, cause number CR 265 to the charge of sexual assault of a child. Defendant has pled guilty. The court has accepted his plea of guilt. The court hereby, pursuant to the plea agreement, defers the finding of guilt, places Mr. Skinner on 10 years community supervision, orders him to pay $290 court cost, $175 reimbursement fees. The court finds that this offense is susceptible to a finding of Chapter 62, and that the defendant is required to register as a sex offender in accordance with that chapter. The court finds that this
registration requirement will last the entire life of Mr. Travis Skinner. In CR 2226, to the charge of bail jumping and failure to appear on felony, court finds that there is sufficient evidence. The court has accepted Mr. Skinner's plea of guilt. The court follows the plea agreement. Court finds Mr. Skinner guilty of that offense, assesses his punishment in accordance with the plea agreement at 10 years confinement in the Texas Department of Criminal Justice Institutional Division, orders him to pay a $2,500 fine, $290 court cost, and $160 reimbursement fees, and the court awards Mr. Skinner 35 days credit towards that sentence for the time that he has spent in jail on this cause. Mr. Skinner, you hereby remanded to the custody of both the Van Zandt County Sheriff and the Van Zandt County Community Supervision and Corrections Department so they carry out the terms and conditions of each of the sentences respectively. I'm going to have the deputy come to your table there, and we're going to take your fingerprint. All right, deputies, if you'll go ahead and take Mr. Skinner into custody at this time. Yes, we're returning to council table.